State, you ready?
We are, Your Honor.
All right, what's your position on this?
Our position in order of witnesses is that it would have to be all of the direct and cross-examination of Ms. Pridgeon, all of the direct and cross-examination of Detective Overfield, all of Ms. Johnson's testimony, direct and cross,
Correct.
all of Dr. Stephanie's testimony, direct and cross. The three that are a little more complicated are Detectives Cadis, CST Live and Good, and the defendant. I mean, we're getting into an area where what does related to mean? There's an argument that almost all of their testimonies would be related to count one. I guess we're sort of looking for guidance on those, but the ones I announced to the court, we agree they have to all be read based upon the request from the jury.
All right. So you're saying the issue you have is with Mr. Loyd and what part of his testimony would relate?
Yes, Your Honor.
Okay. And just determining what part of that testimony is related to count one?
Yes, Your Honor.
Okay.
Same with Sergeant Cadis or Detective Cadis.
All right.
And then the same thing with Ms. Livengood.
Yep. All right. Mr. Lenneman?
Yeah, I'm in agreement mostly with what Mr. Williams says. I think the issue about the perimeters of Mr. Loyd is that we have both the heat of passion and the insanity defense and the self-defense all in his testimony. And there are some aspects of the insanity defense that are not present when he talks about specifically Walmart, the state of mind and so forth, the events that occurred with the press, and him believing the police are going to kill him. In terms of Detective Cadiz, again, I don't have that in front of me, but I think what's relevant here is that the defense has said there has been a conflict in the investigation. He's involved with making statements to Mr. Loyd. He's involved with the casing or the projectile that was found by Detective Overfield. And so I don't know what else the perimeters of his testimony is, but unless we hear differently from the jury, I think we have to read all of it back.
I'm not in agreement that we have to read all of Mr. Loyd's testimony back, because all of the stuff about Sade Dixon and all that.
I agree with you on that, Judge.
So I can tell you right now, I'm not reading the whole thing back.
I agree with you. I think a starting place may be when he talks about the news.
I think what I'm going to do is read the jury this instruction on this one, which is, again, it's 4.4, but it's paragraph 2. I mean, I don't have to read back testimony. It's in the discretion of the court. I'm inclined to read back testimony when asked.
Yes, ma'am.
This is a major chunk of the trial. We would spend about 8 hours reading back testimony with this. So, members of the jury, I've discussed with the attorneys your request to have certain testimony read back to you. It will take approximately, I'm going to guess, based on how long all these folks were on the stand, that we're talking 4 or 5 hours of reading here. So that's what I'm going to tell them. To have the court reporter prepare and read back the requested testimony. I now direct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you should write down as specific a description as possible of the part of the witness's testimony that you want to hear again. Make your request for reading back testimony as specific as possible. because this is in essence an entire day of reading back.
I understand, Judge,
Which
but
is-
my position is, I understand about Mr. Lloyd's testimony being narrowed down to the precise issues, and I think we can do that. But I think Ms. Pridgen, and I'm in agreement with Mr. Williams on that, Ms. Pridgen and Julia Johnson have to be read in whole. Overfield's testimony is pretty short. I don't know what they're looking for. But
I don't disagree with you.
Right.
I can't, though, start nitpicking which one of these I want them to be specific about, because then it looks like I'm reluctant to read a certain person's testimony back.
Well, this is my position, Judge. I do not want a reference to me as an attorney, as one of the attorneys have talked about this, because I think that infers that I'm in part of putting pressure on them to narrow their decision and get on with their verdict, and that's not what I want to do. I don't have a problem with the rest of your statement that says, you know, it's going to take 4 hours, go talk about it. I don't have a problem with that. I just don't want to be part of the lead-in.
That's a standard jury instruction. It says the attorneys. I can insert the word all of the attorneys. But, I mean, this is the standard jury instruction. I can tell you that I've been involved in more readbacks than I care to be involved in. And if you have to be careful when reading these instructions to not, you have to read the instruction. State.
We don't object to Your Honor's proposed reading of the instruction. I would just ask the court to put the number of the instruction on the record.
It's 4.4, paragraph 2.
Thank you, Your Honor. But we don't have an objection to the court's proposal.
Yeah, I did. I thought I put that on the record. Can you all not hear me? That's why I'm asking.
You may have, and I missed it, Judge. I'm sorry.
Yeah, it's okay. I just want to make sure you could hear me. So let me take the mask off. What? Can they eat dinner at the, well, yeah, we need to get going because they need to eat dinner. So I need them to narrow this down. This is just way too much readback. And I suspect they're looking for specific issues. So I'm going to bring them in here and read this instruction to them and send them back in there and tell them that we are going to send them home, or home. We're going to send them to the hotel at 7 o'clock. So let's get them in here.
Judge, just for the record, I understand that that's a standard. I just object to the all attorneys.
I'm just going to read it the way it is. I've discussed with the attorneys your request to have certain testimony. I don't think that singles you out. It says the attorneys. I have 2 here and 2, well, 1 over here. Mr. Marrero has disappeared. So, all right, let's bring the jury back in
So
here.
actually, just so we're clear, I'm objecting to the.
I've got it. You object to me reading the word attorneys.
No, I'm actually objecting now to this being read.
Okay, I've
Okay,
got it.
Thank you.
State recognized presence of the jury.
Yes, Your Honor.
Defense? Yes. All right, good evening, folks. So I've got your list of all the witnesses. I take it this is in addition to Captain Carter and the others. All right. So I have an instruction to read to you all. And I know you want to go home soon. Just going to need to read this, send you back to the jury room for a minute, and then we'll send you back to the hotel because it is almost 7 o'clock. Members of the jury, I have discussed with the attorneys your request to have certain testimony read back to you. It will take approximately, between both requests, somewhere between 4 to 6 hours to prepare and read back the requested testimony. I'm now going to direct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you should write down as specific a description as possible of the part of the witness's testimony that you want to hear again. Make your request for reading back testimony as specific as possible. So if there's some specific issue you're focusing on, that kind of thing, let us know as specifically as possible, because this is 4 to 6 hours of reading. Okay? So last time, I'm sending you back to the jury room. Send me one more note. All right, thanks. Okay, so the jury has narrowed their request. Count 2, Captain Carter, position of the car in the parking lot, how he was positioned, how the car was positioned, exact interaction / encounter between Loyd and Captain Carter. And then it says same with Markeith's account on what happened. Count 1, Monica Pridgeon, exactly what she saw and where she was positioned when the shooting happened. Julia Johnson, that she believed Officer Clayton fired first from when she went to the garden center, her timeline. Count 1. And then count 1, Dr. Joshua Stephanie, which shot disabled Lieutenant Clayton from moving. And then Pete Caddis, trajectory path of Lieutenant Clayton. Y'all want to look at this? This is what it says. So they have narrowed the request down. So I'm going to bring them in, send them back to the hotel. Court reporter, obviously, you're going to need this to figure out what the portions of the testimony are. So I'm going to put this, let's bring them back in, and then y'all can look at the notes afterwards. So I can send them back to the hotel and instruct them for the night. What? Oh, yeah. Yeah. Is she telling them to bring the verdict forms into the courtroom with her? Because they have to get the what? Okay. All right, thanks. State recognized presence of the jury.
We do, Your Honor.
Defense? All right, folks, that was very helpful. Thank you very much. So we'll narrow it down. We'll start the read back tomorrow morning at 9:30. I'm going to send you guys to the hotel since you told me you wanted to quit now, and it's been a very long day for you. So here are the rules. You cannot discuss this case among yourselves unless you're in that jury room. So when you go back to the hotel, on the ride to the hotel, you can't talk about it. All right, take a break from it anyway, folks. All right, clear your heads. So you cannot resume discussions until you're back in that jury room. I'm going to give you this manila envelope. I'm going to give the deputies this. You hand it to the foreperson. If you have done any work, I don't want to know, don't indicate in any way, shape, or form. If you have done any work on any count that involves a verdict form, you are to place it in here, seal it, and have the foreman sign across, the foreperson sign across the seal, all right? If you haven't done anything with the verdict forms, then you don't need to do that. But if there's any verdict form that's been marked, it needs to go in here, sealed, foreperson to sign across the seal. It will be opened by the foreperson tomorrow morning, all right? Because we will gather up all of the evidence and gather up this sealed envelope if it's sealed, all right? Yeah, you can actually put them all in there if you want. But like I said, if any of them are filled out, sign that, seal that manila envelope. Any questions? Everybody know what you're doing? All right, I'll get a good night's sleep, have a good dinner. I'll see you all tomorrow morning at 9:30. Thank you. All right, question, the narrowing is up here. Y'all need to take a look at it. Court reporter's going to have to take a look at it also to make sure we get this straightened out. They need to be here at 9:30. You all need to be here at 9 so we can talk about this, make sure we're straightened out on what's being read to them. What does this do to your schedule for tomorrow?
Destroys it.
Well, let's talk about that in a minute. All right, anything else we need to talk about this?
Well, yeah, only that I'm reading through Ruth's testimony, and I see him identifying one casing from Carter's. I was under the impression that a projectile was introduced as well from Carter's, but I don't see it in there. If the state can correct me if I'm wrong, but I received to get introduced the projectile, one projectile that was tested in Ruth's testimony. It's very narrow.
State,
If by introduce, we mean have the testimony read back to the jurors, we would object because it's not been requested.
this is a specific request for readback, and they have not requested it. The court has, at this point, no grounds to read something back that the jurors have not requested, and it would place undue emphasis on that testimony if I suddenly, on my own, started reading it back. But it's late, folks. We're going to recess for the night, and I'll see you all at 9 o'clock tomorrow morning. We'll go over anything we need to before the readback. All right, court's in recess.